He wrote down his objections and he has opened his mind.
No, I'm saying there is no controversial application. That's my point. We will discuss the deposit part later.
Mic on kar lo.
Mic karo na.
On.
Yes.
राहुल अशोक के पास पानी है? नहीं मेरे पास
Well, the challenge in this appeal is the order passed by the first appellate authority, which is at page 28. That is 26/11/25. Wherein?
Yes.
Got it? Wherein the order passed by the first adjudicating authority under 74, passed under DGST Act, has been held.
Ashok, one sec. We have annexed only one order here. There are no show cause notice, no adjudication order. There is only one appellate order because the point was limited. We wanted to argue for all of you. This should have been updated by registrar.
So in 107/11, he has confirmed the order of the adjudicating authority. Now I will invite this tribunal's jurisdiction and the obligation of the tribunal, that is section 111. What is the role of this appellate tribunal? How this appellate tribunal has to go? Section 11, 111, 1. Section 111 of the Act I am reading.
पीछे वाली है
थोड़ा आगे
बस ये रहेगा. May I read one? The appellate tribunal shall not, while disposing of any proceedings before it or an appeal before it, be bound by the procedure laid down by the Code of Civil Procedure 1908, but shall be guided by the principle of natural justice, subject to other provisions of the Act. So this tribunal has to keep in mind the principles of the natural justice. First and foremost order my submission is that the order has been passed only under the DGST Act, and so is the appellate order. To go to that, this section, obligation of the proper officer under section 62A. Which I have given at page 19 in the grounds of appeal. The impugned adjudication order upheld by the Appellate Authority creating a demand of liability of DGST alone amounting to 4,75,75,000 is a non-est order in view of the having been passed in violation of section 62A of the DGST Act and 62 of the DGST Act for reference to the purpose below. 62A reads as under subject to the conditions specified in notification issued under subsection 1, where any officer, proper officer issues an order in this act, he shall also issue an order under Central Goods and Services Act as authorized by the said act under the intimation to the jurisdiction officer of the sender tax. So there is an obligation upon him under section 62A to pass both the orders. Then even the scheme of the enactment also says that the only one authority has to pass the order. Even in recently managed armored security case, I'm just giving it. Stressing upon the point that but page 62 starts the armor securities.
Page
62 starts the judgment of the armor securities. Last message is in the last. Page 121 on that. I will be reading out of that. Start one, 63 rather, 63 sorry, armored securities, judgment by Supreme Court. अभी तो पेपर बुक दिया उसमें.
63 पे आर्मर सिक्योरिटी तो नहीं है.
देखा ना? I'm reading para 91 of the judgment at page 121, internal page 59 of 66. Para 91 है judgment page number 121 running and internal of the judgment is 59. You got it?
Yes. I don't have a paper book. You didn't give it to me.
I've given you a copy. एक उनको दे देना.
I don't require. Don't worry.
Okay.
Yes. I don't require at all. Good.
Yes. What is the purport of an order under section 62A? It is only to the extent that stressing upon the point that one authority has to pass orders under both the act. That is the scheme of the act and that is judgment of the act, that one authority should dispose of this adjudication there. So I am reading that para 91, clause A of subsection 2 of section 6 of CGST stipulates that where any proper officer issues an order under CGST Act, he must issue an order under SGST Act or UGST Act in order to intimate the jurisdictional officer of the state tax or union territory tax the provision reads as under, subject to the conditions specified in the notification issued under section 1, where any proper officer issues an order under this act, he shall also issue an order under the State Goods and Services Act or the Union Territory Goods and Services Act as authorized by the State Goods and Services Act or the Union Territory Goods and Services Act as the case may be, under intimation to the jurisdictional officer of the state tax or the Union Territories. In Constitution section 62A, it is imperative to have due regard to the legislative intent permitting the GST enactment section 6 in particular advances the objective of establishing a unified national market for goods and services and to prevent taxpayer from undue hardship of being subject to records of multiple jurisdictions. The provision serves a twofold purpose. First, to insulate taxpayers from the perspective of being proceeded against by more than one authority for the same subject matter, and secondly, to vest in as a safeguard against the prejudice which may arise from the initiation of the parallel or overlapping proceedings against this
My
same
Lord,
taxpayer
I have one issue to say.
by different wings in the department.
This matter has come after Supreme Court judgment. So we should be very careful whatever we're listening. Okay, this tribunal is bound by what Supreme Court has said. All these issues, in my view, they have no relevance to the case at all.
Sir, allow me to persuade my lords.
Carry on.
Allowing me to persuade my lords to come to a conclusion that is an honest order.
Yes.
Once it is an honest order, the order doesn't exist at all.
Even that doesn't help.
Once this order doesn't exist in all, it is not executable order.
Okay.
You cannot give effect to it once an order, dead body, neither you can file any appeal against that, neither you can file any limitation starts. Limitation will start because 107 says when there is an order. When there is no order, where is the question of starting of limitation or ending of limitation?
There has to be a finding that it is a non-est order.
This tribunal.
Please remember this thing. That
I am very surprised, Your Honor. They have went to High Court 3 times, they went to Supreme Court 2 times. No issue was taken at all. How can you report a fresh bill before tribunal? Tribunal has no jurisdiction to hear this matter.
Argue first, I will argue later on. Let him argue.
यही होता है कोर्ट में, यही सीखना है आपको. चलिए.
this case has a checkered history.
Let it be.
2 times High Court.
Let me tell you, this case was put up by both of us just to explore the possibilities. Can there be an appeal under these circumstances without any deposit? Will section 1076 will be applicable here, including limitation. But this was the only legal issue. But once you have a history like this which we'll discuss, you have to really appreciate what we're going to argue.
Thank you. Sir, any further arguments? You argue first, I will argue later.
Carry on.
Let the government come.
No, it is only for them. So not for you.
Not for me. Not for the member.
Not for members also.
Public. So what I am saying is that the provisions of 107 will apply only once there exists an order. Yes. If we go to 107, let us go to 107 again. Very good. 107.1. Any person aggrieved by any decision or order passed under this act may file an appeal matter. For a minute I am pausing here. Suppose and there is an order which is passed up to the time limit set out under 73-74. Will it affect my right? If it doesn't affect my right, can that time bound assessment can be given effect to? Can you make recovery?
Some authority has to declare that it is time bound.
I'm before the tribunal to say, I'm trying to persuade the tribunal that to hold that it is a time bound. I will be persuading it. Rest job is my last job. I will be only opening my mind to persuade this tribunal that this order is non-est order, even though he has extracted a number of times.
Some authority has to declare that it is a non-est order.
Let this authority declare.
No, but
This authority is to follow the principle of natural justice.
This tribunal is the creation of the statute.
Yes.
We have to work within the 4 corners of the statute.
Yes.
Now see section 112 and subsection 8.
You see 111, my lord. 111 first.
We have heard you on 111.
Yes,
See,
that's
112 and 8, subsection 8.
yes.
It says, you read it. 112, subsection 8.
No appeal should be filed under subsection 1 unless the appellant has paid.
Please speak loudly.
8 you are asking.
Yes. Subsection 8.
No appeal should be filed under subsection 1 unless the appellant has paid in full such part annual tax, annual returns, penalty arising of this into an order issued by him a sum equal to 10% of the remaining amount of tax in dispute in addition to the amount paid under subsection 1.
Subsection 8, please note, starts with the words, no appeal shall be filed.
Yes. Yes.
There is an embargo even on the filing of the appeal unless you have deposited this 10% of the amount in dispute.
Then
X
I will
amount in
say
dispute.
that
So
this is
how
part-
can we, how can we hear this appeal
Then
unless
I
this
will
10%?
come to that another issue.
We can enter the arena of appeal only when this 10% has been
Absolutely.
deposited by you.
This tribunal has an inherent power also.
Inherent power does not go beyond the statutory
Yes.
provisions.
So natural justice demand to see whether the order which is coming before it is a non-est order or is a not non-est order.
No, we have merely because an appeal has been filed, and which is even as per the statute, it is known to have, not deemed to have been filed even. Can any authority whether it is the first appellate authority or the tribunal, can they declare an order to be non-est?
Yes, my lord, if you have a look, I will give this paper book.
Yes.
I've just given a paper book.
Remember, we are not exercising jurisdiction under 226.
Yes, I'm only saying.
Our jurisdiction is restricted.
I am only saying. I am
under-
only saying that once there is an honest order, then even law of limitation will not apply.
No, Mr. Babbar, but it is your version, it is known as prima facie, it may be. But since we are the creation of the statute,
Yes.
we cannot declare
I will come
unless, yes, as I
I-
said, that we
I
enter
will-
that arena of appeal.
I will support myself with judgment of Punjab and High Court.
Yes, please.
But just a page 31 of paper book. There is judgment of Punjab and High Court, Chandigarh. This is only called the submissions that if it is a non-est order, then no limitation will apply. Matlab para 7 I am reading. Page 34, para 7. To that extent, let the submission be there. That if the order is a non-est order, held to be a non-est order, whether limitation and all these conditions will apply or not. As regards argument of the appellant regarding limitation, it is established legal position that there is no limitation if the suit property is based on inheritance. In the instance case, more mutation 441, being a non-est in the eye of law and having been sanctioned illegally by the revenue authorities, thereby giving rights to persons who were not entitled as per law, could not be sustained. In this regard, I am in complete agreement with the observation of the reasoning as recorded by the lower authorities in its judgment decree with this. Moreover, mutation activity D5 was non-est in the eye of law, being not sanctioned legally by the revenue authorities, giving rights thereby to those persons defendant who are not absolutely entitled as per Hindu Section Act in the property of female. And then, therefore, the point of limitation would, last two lines, point of limitation would not put any hurdle in the claim of the plaintiff. If the order is had, that is, I am just giving a.
No, it is just a suit. It is a case of.
It is principle of law. Principle of law is there.
Principle law.
That principle
How
of
can
law
this
is
judgment
there.
apply? How can this judgment apply where?
I'm saying that if the
Himself saying that it's a non-est order.
once it concludes a non-est order, then the limitation will not come into play. It can be challenged. Then, this page 36.
Some authority has to say that it is a non-est order.
Well,
High Court has ample jurisdiction. Maybe that your remedy is elsewhere, not before this tribunal.
But we are debating a point also that if the orders are of this type, whether non-est order can be hurdled to us or not. And page 37 is the Punjab and High Court judgment.
Mr. Babbar, this argument or this legal ground could have been taken by you
When you are before the
when you were before the High Court.
or the Supreme
Or
Court, yes.
when you file a SLP before the Honorable Supreme Court.
Legal ground.
Since yes, it can be
My submission
legal grounds can be
Can
taken,
you
but
consider that legal ground?
but this legal ground is not for us because we are bound by the
I
statutory
am
authority.
trying to persuade this tribunal. This
Okay.
is of the tribunal.
Okay.
Then I am just having a judgment of
You are referring to Punjab and Haryana.
Punjab and Haryana, Punjab State Power Corporation or State of Punjab and others.
Yes.
That was under the earlier fee of Punjab Act graduate tax. Summary of the judgment I am reading, the High Court, page 36.
Yes.
The High Court, led by Justice Ajay Kumar Mittal, thoroughly examined the legality of 62(5) of the VAT Act, which mandates a 25% pre-deposit total amount tax penalty and interest before an appeal can be entertained. The petitioner contends this condition was erroneous and violated Article 14 of the Constitution creating arbitrary discrimination. Referring a plethora of Supreme Court and High Court judgments, the court upheld the validity of 62(5). The judgment emphasized that the right to appeal is statutory right, inherently subject to conditions prescribed in the legislature. The court concluded that the 25% pre-deposit requirement was not excessively burden and served the legitimate interest of the ensuring timely recovery of taxes, maintaining a balance between the taxpayer right to appeal and the state's fiscal interest. Additionally, the High Court addressed whether the appellate authorities possess inherent power to grant interim protection against such condition. It affirms that appellate authorities retain discretionary power to waive or modify pre-deposit requirement in cases of genuine hardship, ensuring that statutory provisions do not render the right of appeal a mere illusory. This is one of, I'm relying upon that only. Then I say that on the conditions that whether these conditions can be waived or not waived, maybe by this forum or by the other forum, I have a judgment by my own argued, which is page 44. It is argued in writ before the Delhi High Court. But I am saying on the principle that it can be waived. That is the only thing which authority will be there. That it is. Page 44.
Mr. Babbar, since you are referring to High Court, there is a judgment of our own High Court in Impressive Data Service Private Limited versus Commissioner. They say that Delhi High Court marks the decisive ruling on the non-waiverability of the pre-deposit requirement under Section 1076 of CST Act. Delhi High Court held that no judicial discretion exists to waive the mandatory pre-deposit relying on the binding precedents of the engineering technoplast versus CCA.
So I'm also giving you Delhi High Court, in which it is argued by me itself, and the last line will come down.
Yes.
There was a demand of 8 crore valid in this, in the order.
45 page number.
Page 45. Some taxes were paid, they were not considered at all. And this appeal before the tribunal has been taken into account without any pre-deposit. It has been entertained. Para 17, what?
Para 17?
Page 50 of this judgment, AT&T Securities.
Yes.
However, in the facts and present case, considering the substantial amount of money which has already been paid to petitioner, the court is of the opinion petitioner ought to be permitted to avail appeal remedy before G State Appellate Tribunal without any further payment of any amount.
Further payment of pre-deposit.
No 10% has been paid.
Yes.
Demand of the order remains 10%. And this appeal has been admitted in present tribunal in Delhi.
But
It is the High Court.
High Court which has done this.
We are only on the conditions that whether it can be waived or it can't be waived. It is a waiving effect. It can be waived. Considering authorities, this authority may say, I have no power.
But do you think this is the order? This that will hear without deposit?
Yes.
No. This order means something else.
Read it para 17 yourself.
We will discuss later, not here. I have read this order. And your order is,
Moot code in yourself.
your order is much earlier than what honorable member is saying.
Yeah. Then you stay with the thing.
Chalo.
So
Mr.
the-
Babbar kindly appreciate two things. Firstly, so far as
Sir, this tribunal has, the Goods and Appellate Tribunal has entertained this appeal without any amount.
on the directions of the High Court.
Mylan may record my submissions and hold the view.
Yes, yes.
Kindly appreciate Article 141, which says that whatever is the order of the Supreme Court, that is binding on all the lower courts. And then when the Supreme Court has directed, you deposit the 10% fees, how the tribunal can entertain this appeal?
Then Mylan may hold it. Mylan may hold it. This appeal has been accepted by the Revenue. Revenue has no objection. They have not filed any cross objection. It is a consented in a way.
But this is an interim order. Interim order, not
Either
binding.
the government.
This is an interim order, not binding.
No final order.
Yes.
It is a final
It's not a
order.
final order.
Yes. Which
Okay.
Deposits are not interim final order.
No, in which appeal
Don't
you are saying-
intervene or argue first.
Mr. Babbar, in which appeal you are saying? Your appeal you are saying that Revenue has not filed cross appeal.
No, they have not filed. Telling this order of High Court is attained finality.
Why should they challenge High Court in the exercise of writ jurisdiction? as
They can,
stated?
if they are aggrieved, they could have gone to SLP.
No, why should they be? If they may.
That is what I am saying. If they are not aggrieved with one another, they can't take a different stance.
But this was the jurisdiction of High Court. We cannot exercise the same
Sir,
jurisdiction.
you all stand-
I just appreciate two things. So far as this CGST Act is concerned, or DGST Act is concerned, under section 112, there is an embargo on the jurisdiction of the tribunal, even to file on the appellant, even to file an appeal unless 10% is deposited. Earlier statutes, the words were no appeal shall be entertained, which meant that the appellate authority or the tribunal could give more time
Yes.
to deposit the amount. Here we don't even have the time except the period of 3 months
Acceptable.
plus 1 month.
My
You
only
cannot-
thing is I want equality.
Yes.
In this case, the appeal has been admitted in the GST tribunal without any pre-deposit.
But that was on the direction of the High Court. You go to the High Court. If High Court directs, we will also entertain
You
your
hold
appeal.
it, mind me.
Under the directions of the, they are the federal powers. They can do it.
And secondly, may I
नहीं
come?
अभी नहीं
अच्छा, अभी कौन-
अभी टैक्स मिलेगा या मैं अरेस्ट कर ले तो मैं फिर आ जाऊंगा दोबारा.
And please see, in some of the statutes, even in one of the cases, I think it was under the Tripura enactment, pre-deposit of 50% was also upheld by the Supreme Court. But then there was a proviso in those provisions that the Appellate Authority was given the power to waive that condition of 50% or whatever condition was imposed by the statute. But here, there is no power with the Appellate Authority to waive this
But
condition
sir,
of
there
50%.
is no issue at all or question at all that this appeals before the tribunal cannot be heard without any pre-deposit. This is a case, classic case, where the appeal has been entertained by the tribunal.
No, tribunal has not entertained. Only on the direction of the High Court the tribunal was
Yeah,
bound.
let it be. I want parity.
Yes.
Malan may say that so in the
Yes,
order.
yes, yes.
Then Malan has similar situations.
Yes.
Then again, in that case also, you have deposited some money. Some
No,
money had been,
it is prior to adjudication, during adjudication.
Whatever the state, the court
Payment
says,
was there.
that amount has been deposited.
payment was there. However, the facts of the present
Substantial amount
case,
of money has
considering the
Malan may hold it, that
substantial amount has been deposited by
the
you.
issue is whether waiver without any deposit, this appeal can be entertained or not. My answer is it can be entertained. Second, Malan may see that I am giving another example of order which is can be called in time bar.
Yes.
There is second, I have just argued before the Punjab Haryana High Court, that is judgment of Trilok Chand. Where is a beautiful, the facts are that a dealer applied for cancellation of registration certificate. His cancellation was accepted. Then for the assessment purposes, he was given a notice on the portal. Then there is an order coming in 24 after 2 years by serving notices on the portal. Then we said that I did not know because a person who is out of business cannot be supposed to know that you have issued any notices. On this case also, after 2.5 years, the High Court has entertained the rates and they have stayed the whole recovery. Mine have page 51, page 52.
High Court has ample, Mr.
I'm
Babbar,
only-
you are repeatedly saying that High Court has ample power. Their jurisdiction is very wide, even wider than
Supreme Court.
Malan may come to page 53, Malan may come to page 53,
Yes.
that is Shimla Gomti, where the Supreme Court has reduced to 50%.
Not again the condition. We are misguided.
Let us read.
That's a misconception among all the fraternity that it has been reduced condition of 10%.
So Malan may explain.
It is not that.
Malan may explain, I will also submit.
Yes.
Malan can hold.
They
I
have
can
only asked for a deposit with the registrar. Appeal is still to be
Last para
heard.
of the judgment.
Appeal is still to be heard in that matter.
Read the last para.
Yeah,
of the judgment.
government counsel should be allowed to speak first. I will conclude. I'm saying.
No, we're discussing law. We're discussing law. I'm not disturbing your rhythm.
Rhythm is immediate. It will not
It's
be
a judgment.
It will not be affected. It is a judgment. It is only on the point of law that whether fixed amount of 670 was required. The courts or any forum can reduce it. It can
Now
reduce
give me
it.
back.
Any forum, only the High Court or the Supreme Court can.
Yes.
Mr. Babbar, will you read para 16 of the judgment of Gomti?
Yes.
Yes. Or I will read.
You read it. So no.
We direct the petitioner to deposit an amount of rupees 3.50 crore with the concerned department within a period of 2 weeks from today. The department shall acknowledge the receipt of the said amount in writing. Once the amount is deposited, the receipt of the same shall be produced before the registry of this court upon production of the receipt of the deposit. The registry shall issue notice to the respondents returnable on 11/5/26. Since the petitioner has agreed to deposit the sum amount of 3.50 crores within the aforesaid stipulated time, no coercive steps shall be taken pursuant to the two assessment
No.
orders.
Now the issue
There is
is
no,
if,
there is no,
if the 10% has been a too tight bracket, then they could not have done it.
there
They
is
would
no
say,
pension of 10%.
No, it is immaterial. 670 was a pre-deposit amount which you didn't deposit.
Did not apply to Supreme Court. As I said, they have High Court as well as
That means that only thing is that 10% deposit is a flexible issue.
No, it is not a flexible.
It is a flexible.
So far
They
as
could not have passed this
statutory
order.
authorities are concerned.
They couldn't.
So far as statutory authorities are concerned, this 10% is not flexible.
My lord.
But High Court and the Supreme Court, they have ample jurisdiction to waive.
But I'll be needing parity with vis-a-vis 18 cigarettes.
High Court under 226 has much
Can-
more
yes,
powers,
much more,
larger
yes.
powers than the
Even than
Supreme
that,
Court.
yes.
Okay. Then I'm giving you another one. Where latestly for academic purposes. There is a page 60, there is Supreme Court judgment, that is only academic only, nothing more, so nothing says.
60.
Page 60.
Yes.
It is again a Supreme Court where the notice has been issued on a parallel provision of central excise. Made in page 60. It is Morthala Siddha Reddy.
Last week. Came last week.
Yes, last week.
It came last week.
Yes. But not SRE, SR leave कर दिया मैंने page 60 or most probably 61.
It is 60, yes, 60 also.
Morthala
इनकी अपील में लास्ट में
नहीं सर Morthala Siddha.
yes it's with your
You know,
appeal
page 32.
61.
Page 32.
Page or in the appeal page 32. In the appeal also next page 32.
it's enclosed
Yes.
your appeal.
Yes.
No.
The short one that falls for consideration is whether for the purpose of condoning delay insofar as section 85(3) of A of the Finance Act is concerned, whether section 5 of the Limitation Act would apply or not. We heard K Babbar, the learned senior counsel appearing for the petitioner. In the course of today's hearing, the learned senior counsel brought to our notice a 3-judge bench decision of court in Commissioner of Customs Central Excise versus Hango India Private Limited and other, reported in 2009-5 Supreme Court Case 791, and also decision of 2-judge bench of this court in the case of Union of India with Popular Construction reporting this. Issue notice returnable that Supreme Court has chosen to examine this excise law, but also pre-deposit this limitation law of limitation will apply or not.
Yes.
On this issue, they have issued that means the matter is under consideration and debatable. It is debatable. So with all this, I will only conclude my argument that seeking parity with my 8 AT&T securities, let their appeal be heard without any deposit and without any consideration.
Hard and dismissed.
This is unfair. This is unfair, and tribunal should take strict action against him. He should have condemned notice. He should have condemned notice. He has gone out of that one.
But unfortunately, we are in Moot Tribunal.
Okay,
Hello,
sir.
can I start? I think we'll argue this for 10 minutes, the legal issue raised by my learned friend Ashok Babbar.
Because we are constrained to say that, sorry, being statutory authority, we cannot.
Let him.
It's beyond our powers.
Sir,
But
further,
my lord, I would like to argue this matter.
sir, further Moot High Court में एंगल से आर्गू कर देंगे
Ashok, Ashok, so up to mention being made of section 111. Because I know,
सर ट्राइब्यूनल का डिसीजन आ गया आपने क्या करना है
there's no decision yet.
नहीं
Maybe decision changes.
no
You never know.
नहीं decision they were announced in your favor
Now you honor.
sir nothing has to argue nothing now
No, but you are not fair to appealing on this.
no
The appellate tribunal shall not, while disposing, shall not. It is followed by a comma. This interpretation is very strong here. Otherwise, the legislator will not put a comma after shall not. While disposing of any proceedings before it or an appeal before it, be bound by the procedure laid down in CPC, but shall be guided by principles of natural justice. My friend stopped here. There's a word and after this.
Subject to the.
Now, this and has very importance. All of you read together. You have to harmoniously construe this provision and subject to other provisions of this act and rules.
You
Section
mean that natural justice is not to be followed?
Huh?
You mean natural justice is not to be followed?
Wait, yaar, let me speak.
Why?
Maybe I support you.
I will also.
Maybe I support you, sir.
Sir, I will also opposing you like that.
Common through that. I never get rattled, you know. You also don't get rattled like I never get rattled. I'm a government counsel, so I never get rattled at all.
So we have to pin you.
Okay, wait. Subject to the other provisions of the, now, my lord, once you read section 111, what is the marginal heading? It's only a procedure. It's not a mandate given by legislation.
It is under a statute.
And the mandate also tells you that national justice is built in. Even if they don't write, it's a built-in provision in common law jurisprudence. I don't have to read this.
And even this has to apply, this section 111(1) would also apply after the appeal has been admitted by the tribunal.
Number two.
Kranti Association.
Number two. You know, if you take these judgments of Honga and all that stuff, including Patel Trading Company in Farm VAT Act, there was section 35E.
That's right.
There they say the appeal shall not be entertained.
This is
Here the dismissal at the time of filing itself.
Yes. This is what I
Now this tribunal cannot touch the jurisdiction issue till appeal is filed. Now we can read the order because my friend has, as usual, strategically has not read the order. That's the strategy we all adopt as lawyers. Don't read which is uncomfortable. This also you have to learn. I'm discussing only we are castigating each other just to make you learn. Let's read the order.
Which order are you reading?
एक ही order है तुम्हारे केस में मैंने फाइल
कौन सा?
Appellate order.
Appellate order. Yes.
28 page.
Appellate pending बोल रहा है ना?
The appellant feeling aggrieved against the order of adjudicating authority dated so and so moved Delhi High Court by way of CWP dated 6/1 praying therein that the adjudication order has been passed ex parte without service of any notice at all and certain SIB reports have been relied upon, copies of which were not given. Let's stop here. He challenged by view of writ petition कि मेरा ये without service note मेरे को document नहीं दिए. हाई कोर्ट ने बोला इनको डॉक्यूमेंट दो, इनकी दोबारा असेसमेंट करो, जाता फाइल अपील. They filed. The petitioner then took an SIB report and appeared before the adjudicating authority. After considering the reply of the petitioner, the adjudicating authority passed a reasoned and speaking order. Your Honor, I am reading to bring up a very important legal point in this particular matter.
All have been considered at the end. All have been gone through it at the end. It is again been remanded back to the appellate authority.
वेट कर लो सर, वेट कर लो थोड़ा.
No, sir,
वेट कर लो सर. आपके जजमेंट को मैंने काटना है ना, जजमेंट पढ़ने की जरूरत नहीं है. They are irrelevant judgment.
वो कट जाएंगे.
They are irrelevant judgment. After considering the reply of petitioner, the adjudicating authority passed a reasoned and speaking order dated so and so. Feeling aggrieved, the petitioner filed an appeal manually before the first appellate authority. The first AA called the appellant for hearing on 3/25. None appeared. Other notice was sent where the counsel Shri S.K. Sharma advocate appeared, Surinder Sharma, and argued that the whole order is a concoction of the mind of the adjudicating authority.
May I say something? Your Honor? ये गलत बयानी कर रहे हैं. सुरेंद्र कुमार शर्मा इस केस में कोई मैं वकील नहीं था.
ये तो दूसरे एसके शर्मा
और क्या?
एसके शर्मा को उन्होंने सुरेंद्र कुमार शर्मा कहा है. मैं नहीं जानता. So I
Adjudicating
made it
authority
clear
wherein
that
a
I
very
am not
high-stake
interested
demand
party in
has
this
been
case.
created, and hence the order be quashed. He was asked to file written submission that he filed on 16/6/25. He was called upon 36/5 for arguments when none appeared nor any intimation or application of adjournment was received. While examining the appeal, it was found that the appeal is time barred and there was no application filed for condonation of delay. Like before tribunal here, there was also no condonation application. This tribunal could have never heard a single argument because he is arguing an appeal here. He is not saying you have no jurisdiction. So once he has to go into the appellate arena, appeal has to be filed. Now there is no delay condonation. If he might say not required. Article 14, now Supreme Court says you still have to file an application. Though it's automatic exclusion for the time taken. But how will the tribunal know what time taken is an honest order or not? So there also they did not file. Let me go it further. Also it was noticed that the appellant did not deposit the mandatory pre-deposit of 10% amount. Hence the appeal was dismissed as time barred and also in limine on 1/7 on non. Now here comes the beautiful part which my friend has overlooked to create a jiggery of all kind of irrelevant judgments. Feeling agreed with the order of dismissal of appeal as time barred and also eliminating the appellant again approached the High Court with the grounds of limitation and pre-deposit waiver. There was no jurisdiction issue taken. It's a non-est order.
Yes.
And that is why I objected that
Wait,
there are
wait,
so many innings before the High Court and Supreme Court.
Let me go further. Why this appeal is misconceived and a abuse of process of law? The COA petition was filed on 4/7 after hearing the High Court by order 975 directed the Appellate Authority to consider the plea of condonation delay in view of the ruling of Supreme Court in case of MP Steel Corporation. MP Steel Corporation is the only Supreme Court ruling which says Article 14 applies to statutory authorities also. All other judgments say it applies to courts only. This is the only Supreme Court ruling which is followed by other Supreme Court rulings now, which says if you are following an alternative remedy like High Court writ or some other appeal, the time taken from beginning to end can be excluded for the purpose of limitation of section 107. This is the only judgment. And he directed the petitioner to appear before, this is third appearance. Instead of appearing before the first level authority as per direction of the High Court, the petitioner approached Supreme Court by way of so and so praying for condonation delay as per Supreme Court ruling in MP Steel Corporation, as well as waiver of pre-deposit of 10%. This is too much. How can they conceal these facts? The Honorable Supreme Court affirmed the order of High Court dated 975 and directed the Appellate Authority to pass the order. However, Supreme Court did not pass any order on waiver of pre-deposit. Let's go further. The Appellant again filed first appeal under section 107 as per direction of the Supreme Court by so and so and prayed for condonation of delay and also waiver of pre-deposit. The appeal was filed on 20th October 25 with an application for condonation of delay as well as an application by waiver of pre-deposit on the ground of financial constraints and demands being illegal as alleged in the ground of appeal. Heard the counsel at length. So what are the factual metrics of this case? Now it comes. Here comes the cat out of the bag. The case was called for a hearing on 16/11, 24/11 and finally on 21/12. Date mistake. 21/12 and the detailed arguments from both sides were heard. The appellant has reiterated the grounds taken before High Court, that is the MP Steel Corporation case for condonation of delay and financial constraints for waiver of pre-deposit 10%, for which no documentary evidence has been filed except an affidavit from the partner of the firm. The application for condonation of delay has not specifically and date-wise mentioned the total period delay involved based on the ratio of ST judgment in MP Steel Corporation. There is no prayer in the application for condonation of delay, seeking condonation of delay on specific period during which the alternative remedy was being invoked by the appellant to apply section 14 of the Limitation Act. Hence, I am left with no choice but to dismiss the appeal as time barred. Also, there is no deposit of 10% of the tax amount made, and there are High Court to there are no orders of High Court to waive it as paid for by the appellant. Hence, I, being a statutory authority under GST Act, cannot waive nor have any power to waive the pre-deposit of 10%. The appeal is dismissed. Now, two serious questions come. First, he mentioned armor security. How is this relevant here? Armor security was concerned with only one issue. Who initiates the proceedings concludes it. Armor security has a section 536 to be discussed to come out to this ratio. Now, if you go into time barring and limiting, this tribunal gets no jurisdiction under any law whatsoever to even hear these arguments.
Mr. Verma, we are already with you. We have dismissed his appeal.
No, Your Honor, this is a there should be cost.
Sir, may look to 107.11. Section 107.11 in the button.
It's over.
Sir,
Thank you so much.
Sir, you will not controlling the tribunal.
Now both of you argue between yourself outside the tribunal.
Sir, 107.11 puts a burden on the Appellate Authority.
Hey, Ashok.
Further inquiry as a deemed fit.
Oh, Ashok.
Without doing an inquiry, he could have counted the number of days. Number of days could have been counted by the Appellate Authority also. That is natural justice.
So this is a new thing.
Yes.
We have argued. We are trying to bring out a new proposition. Can this be done?
Yes.
my 90% opinion, this cannot be done. Somebody has to say, all judgments he has quoted, the language what? It is established. So something was established. Here there is nothing else. In fact, this is not even prayed for. There is no ground of appeal in this. So this is what I told in the beginning. If you want to raise this issue, question of law must come from below.
Yes.
Then if at all it is arguable, 1% chance, this could be argued. Since nothing was done below,